On the morning of February 20th, 2026, inside a marble courtroom in Washington, 9 justices handed down a decision that stopped a president's signature economic weapon in its tracks. 6 votes to 3. Chief Justice John Roberts read the majority opinion aloud, and within minutes, the number 6-3 was trending across financial markets from New York to Toronto to Tokyo. The ruling didn't just strike down a tax policy, it struck down the legal foundation Donald Trump had used for a full year to reshape trade with almost every country on Earth, including the one right on America's northern border. This is the story of that ruling, how it came to be, and how in the months leading up to it, Canada didn't just wait for the verdict, it actively tried to shape the battlefield the case would be fought on. Let's start with what actually happened in that courtroom, because the facts here matter more than the headlines. According to Reuters and SCOTUS blog, the case was formerly known as Learning Resources, Inc. Trump, consolidated with a related case, VOS Selections versus United States. The question before the court was narrow but enormous in consequence. Did the International Emergency Economic Powers Act, a law passed by Congress back in 1977, give the president the authority to unilaterally impose tariffs on foreign goods? The court's answer, in 6 sentences that will likely be quoted in law schools for decades, was simple. It does not. Chief Justice Roberts, writing for the majority, was joined by Justices Sonia Sotomayor, Elena Kagan, Neil Gorsuch, Amy Coney Barrett, and Ketanji Brown Jackson. That lineup alone tells you something about how unusual this case was. 2 of Trump's own appointees, Gorsuch and Barrett, crossed over to join the 3 liberal justices and the Chief Justice himself. On the other side, dissenting, were Justices Clarence Thomas, Samuel Alito, and Brett Kavanaugh. CNN reported that this was arguably the most significant loss the second Trump administration had suffered at a court that, just months earlier, had repeatedly sided with the president on immigration enforcement, the firing of independent agency heads, and deep cuts to federal spending. To understand why this ruling landed the way it did, you have to go back to February 1st, 2025, the day this entire chain of events began. According to the Congressional Research Service, that was the date President Trump first invoked IEPA, declaring a national emergency over the trafficking of fentanyl and its precursor chemicals into the United States. Using that declared emergency, he imposed tariffs on imports from 3 countries specifically: Canada, Mexico, and China. Then, just over 2 months later, on April 2nd, 2025, he declared a second separate national emergency, this time citing what the administration called a chronic and damaging trade deficit. Under that declaration, he imposed a baseline 10% tariff on goods from nearly every trading partner the United States has, plus higher country-specific rates that officials nicknamed reciprocal tariffs. Here's the detail that made the legal case so strong for the challengers, and it's worth sitting with. Roberts wrote, and this is according to Rolling Stone's coverage of the opinion, that in IEPA's roughly 50-year existence, no previous president had ever invoked the statute to impose tariffs of any kind, let alone tariffs of this magnitude and scope. The law had traditionally been used for things like freezing the assets of foreign adversaries or blocking specific financial transactions tied to sanctioned regimes. It had never once been used as a tool to unilaterally tax imported goods. That absence of precedent became the core of the court's reasoning. The administration's argument rested on a single phrase buried in the statute: the power to, quote, regulate importation, end quote. Government lawyers argued that regulating importation logically includes the power to tax it. The court rejected that reading outright. According to the opinion as quoted by CNBC, the justices wrote that to justify what they called an extraordinary claim of power, the president needed clear and explicit authorization from Congress. He cannot, the court concluded, point to that authorization. 3 words: he cannot. That phrase alone became the headline in outlets from the Associated Press to Al Jazeera within the hour. Now, before we go further into how this played out for Canada specifically, it's worth pausing on the money at stake, because the scale here is almost hard to comprehend. According to CNN's reporting, more than $130 billion in tariffs had already been collected under IEEPA by the time the court ruled. The justices, notably, did not say what should happen to that money. Roberts' opinion was silent on the question of refunds, which the Tax Foundation estimated could ultimately affect duties that were projected to raise as much as $4 trillion over the following decade, if the tariff structure had remained in place. That silence on refunds would go on to become its own legal battleground, one that legal analysts at WilmerHale said would likely take months, possibly years, to work through the lower courts. Trump's reaction was immediate and unfiltered. At a press conference in the White House briefing room on the afternoon of the ruling, he called the decision, quote, deeply disappointing, and said he was, quote, ashamed of certain members of the court, absolutely ashamed for not having the courage to do what's right for the country. According to a source who spoke to Fox News when an aide handed him a note about the ruling during a closed-door breakfast with governors, Trump reportedly called it a disgrace and then continued with his prepared remarks as though nothing had happened. Later, on his social media platform, he escalated further, describing the ruling as costing the country, in his words, trillions and trillions of dollars, and suggesting without offering evidence that some justices had been swayed by foreign interests. That accusation about foreign interests is not a throwaway line. It connects directly to the second half of this story, the part involving Canada, and it's where things get genuinely strange. Before we get there, it's worth understanding just how this case made its way up to the 9 justices in Washington in the first place, because the path matters. According to the Congressional Research Service, the earliest legal challenges were filed not by a foreign government, but by small American businesses. Litigants like VOS Selections, a family-run wine and spirits importer and learning resources, an educational toy company, argued in the U.S. Court of International Trade that these tariffs were crushing their margins and that the president simply didn't have the legal power to impose them. On May 28, 2025, according to reporting from the Economic Policy Institute, the Court of International Trade agreed, ruling that Trump's April 2nd executive order exceeded his authority under IEEPA. That same ruling also struck down the separate fentanyl-related tariffs on China, Canada, and Mexico. The administration appealed immediately, and the lower court's decision was stayed, meaning the tariffs kept being collected while the case worked its way to the Supreme Court. That's an important detail because it means for nearly 9 months, businesses and consumers kept paying tariffs that a federal court had already found to be unlawful simply because the appeals process hadn't concluded. To understand Canada's position, you need the timeline of how the tariffs actually hit the country first. When Trump invoked IEEPA on February 1st, 2025, he initially threatened to hit all Canadian goods with a 25% levy. According to CBC News, that threat was later walked back so that it applied only to goods that didn't comply with the Canada-United States-Mexico agreement known as CUSMA. That levy went into effect in March 2025 and was then increased to 35% over the summer. Because a large share of Canadian exports to the U.S. already qualified under CUSMA's rules of origin, the practical bite of the tariff was smaller than the headline number suggested, but for exporters outside those protections, particularly in sectors like steel, aluminum, autos, and softwood lumber, the pain was real and ongoing. It's important to note here, and this is a point Canadian trade lawyers at firms like Blakes and Fasken have stressed repeatedly, that those sector-specific tariffs on steel, aluminum, autos, and lumber were never part of the IEEPA case at all. They were imposed under a completely different law, Section 232 of the Trade Expansion Act of 1962, and the Supreme Court's ruling in February did nothing to touch them. That distinction matters enormously for what comes next, because it explains why Canada's celebration of the ruling, when it came, was notably restrained. Now here is where Canada's role becomes more than passive. In the run-up to the Supreme Court's oral arguments, which were scheduled for early November 2025, the government of Ontario, one of Canada's provinces, ran a television advertisement on major American networks. According to PBS NewsHour's reporting, the ad used audio from a 1987 radio address by President Ronald Reagan, in which Reagan spoke critically about the economic dangers of tariffs. The ad aired during high-visibility programming, including, according to multiple outlets, during coverage of the World Series, ensuring it reached a massive American audience right as the Supreme Court was preparing to hear the tariff case. Trump's response was fast and furious. On his social media platform, he wrote that the Ronald Reagan Foundation had announced Canada fraudulently used an advertisement, calling it fake, and claiming, in his words, they only did this to interfere with the decision of the U.S. Supreme Court and other courts. He then declared, in all capital letters according to the direct quote reported by PBS, that all trade negotiations with Canada were hereby terminated, effective immediately. The Ronald Reagan Presidential Foundation, an institute for its part, posted on social media that the ad misrepresented Reagan's original 1987 address and stated that the ad's producers, Ontario's government, had not received permission to use or edit the remarks. The foundation said it was reviewing legal options. This detail is independently verifiable, and it's an important one, because it shows the controversy wasn't purely a Trump versus Canada dispute. A nonpartisan American institution tied to Reagan's legacy also objected to how the footage had been used. So is this, in the literal sense the title of this story suggests, Canada weaponizing the Supreme Court case? Here's where honesty matters more than a punchy narrative. What we can verify is this. Ontario's provincial government ran a paid ad campaign timed deliberately to reach a national American audience in the weeks before the Supreme Court heard oral arguments on the tariff case, using historical footage of a Republican icon criticizing tariffs. What we cannot verify, because no Canadian official has confirmed this on the record, is whether the ad's actual intent was to sway the justices themselves, as opposed to simply shaping American public opinion during an ongoing trade dispute. Trump's framing that this was a deliberate attempt to interfere with the judiciary is his interpretation and his alone. Canadian officials have not publicly conceded that characterization. This is a case where the underlying event is real and documented, but the motive behind it remains genuinely contested. And any script that presents Trump's interpretation as proven fact would be getting ahead of the evidence. What is not in dispute is the fallout. Trump's declaration that trade talks were over threw a wrench into months of already difficult negotiations. Prime Minister Mark Carney, according to Yahoo News coverage, sought to downplay the threat publicly, saying Canada stood ready to, quote, build on that progress when the Americans are ready. Behind the scenes, the damage was real. According to the Globe and Mail, White House National Economic Council Director Kevin Hassett later told reporters that frustration with Canada had been building for some time, describing the Canadians as, in his words, very difficult to negotiate with, citing what he called a lack of flexibility. Let's now fast forward back to the ruling itself on February 20th, 2026, and look at how Ottawa actually responded once the decision came down. According to Yahoo News Canadian coverage, celebrations in Canada were, in their words, both brief and muted. This wasn't a case of triumphant relief. Canada's Trade Minister, Dominic LeBlanc, posted on social media that the ruling reinforced Canada's position that the fentanyl-related tariffs had always been, in his word, unjustified. But LeBlanc was careful, according to that same reporting, to note there was still what he called critical work ahead, particularly around the tariffs the ruling did not touch, the steel, aluminum, and automobile duties imposed under Section 232. This is the point where the practical reality of the ruling diverges sharply from the dramatic headlines it generated. William Pellerin, a partner in international trade at the law firm Macmillan LLP, was quoted by Yahoo News as saying that most Canadian exporters, quote, won't see a difference at all. The reason is straightforward. Exports that already complied with the Canada-United States-Mexico agreement had been exempt from the IEPA tariffs from the very beginning. So, for the large majority of cross-border Canadian trade, this ruling changed very little on paper. And Trump didn't waste any time finding a new legal pathway. On the very same day the ruling came down, according to Blake's law firm's analysis, Trump signed a proclamation invoking Section 122 of the Trade Act of 1974, a different statute entirely, to impose a new 10% tariff on goods from nearly every country, with COSMA-covered Canadian and Mexican goods again carved out as exemptions. There's an important legal wrinkle here that's worth explaining clearly, because it shows why this fight is far from over. Tariffs imposed under Section 122 are legally capped at 150 days unless Congress specifically votes to extend them. That built-in expiration date means the Trump administration will likely need to find yet another legal authority or seek congressional approval to make these replacement tariffs permanent. According to the Brownstein law firm's client alert, the White House moved with unusual speed after the ruling, issuing a series of executive actions the same day both to formally comply with the court's order and to simultaneously stand up new tariffs under different legal authority. So what does Canada actually do with a ruling that, as one Canadian trade lawyer put it, changes very little in practice, but that the government publicly frames as a vindication? This is really the heart of the weapon framing, and it's worth being precise about what kind of weapon we're actually talking about. It isn't a legal weapon in the sense of Canada winning a court case directly. Canada wasn't the plaintiff in Learning Resources ver. Trump, American small businesses, and a coalition of U.S. states were the ones who brought the underlying legal challenges. Instead, what Canada appears to be doing, according to a CBC News interview with Internal Trade Minister Dominic LeBlanc, is using the ruling as a rhetorical and negotiating tool. LeBlanc told CBC's Power and Politics that the ruling would help some Canadian businesses, while cautioning that sectoral tariffs on steel and softwood lumber remained a serious concern, along with what he called ongoing uncertainty in trade ties with the United States. That uncertainty is the real story here, and it's bigger than any single Supreme Court case. According to Yahoo News, this legal moment created the first opening for renewed, formal trade discussions between Washington and Ottawa since talks were abruptly halted the previous October, precisely because of that Reagan advertisement dispute. Canada's chief trade negotiator to the United States, Janice Charette, met in Washington with U.S. Trade Representative Jameson Greer's deputy for the Western Hemisphere, Jeffrey Gutman, and then LeBlanc himself met directly with Greer. These weren't ceremonial meetings. According to reporting on the substance of the talks, Canada was pushing hard to avoid an entirely new round of tariffs Trump had threatened, reportedly up to 50% on roughly $20 billion worth of goods, including electronics and alcohol, while also trying to negotiate down or eliminate the existing duties on autos, metals, and other sectors. Greer, for his part, didn't make things easy. In an interview on Fox Business, he described negotiating with Canada as, quote, more challenging than negotiating with Mexico. He pointed to specific irritants, Canada's continued refusal in its framing to allow American wine and spirits onto Canadian retail shelves in some provinces, ongoing disputes over dairy import rules, and a Canadian law called the Online Streaming Act, which requires American media companies like Netflix and Spotify to contribute financially to Canadian content production. Greer characterized these as barriers Canada has, quote, not addressed, calling them a big obstacle to what he termed real negotiations. It's worth remembering, too, that trade friction between Washington and Ottawa didn't begin with this Supreme Court case. Canada has been down this road before. During Trump's first term back in 2018, his administration imposed Section 232 tariffs on Canadian steel and aluminum, citing national security grounds, a move that triggered a bitter and prolonged dispute that was only resolved after roughly a year of retaliatory tariffs from Ottawa and intense diplomatic pressure. That earlier fight is part of why so many trade lawyers in Toronto and Ottawa reacted to the February 2026 ruling with caution rather than celebration. They had seen this pattern before. A legal setback for the White House followed almost immediately by a pivot to a different statute, and they knew better than to assume one court victory meant the underlying conflict was resolved. This is where the Reagan ad controversy resurfaces in a slightly different light. According to the Wire report, obtained via a court filing referenced by the Globe and Mail, Ottawa quietly signaled it intended to eliminate that same streaming tax that Greer had criticized, a 5% levy on American streaming services operating in Canada. The decision only became public when a government lawyer's letter was leaked, revealing that Canada's Culture Minister Mark Miller had already ordered a federal review of a related decision to raise a similar levy to 15%. Some analysts framed this as a concession, a quiet capitulation timed to ease tensions after months of friction. Whether this was directly connected to the Supreme Court ruling or simply part of the broader ongoing negotiation is not something that's been confirmed on the record, and it's worth flagging as one of the murkier threads in this story. Meanwhile, Prime Minister Carney has walked a careful line on what many analysts consider Canada's single biggest point of leverage over Washington: energy. The United States imports roughly 4 million barrels of Canadian oil every day, according to the Globe and Mail, accounting for nearly 2/3 of all U.S. petroleum imports. That is an enormous dependency, and in theory it hands Ottawa significant negotiating power. But Carney has publicly and repeatedly declined to use it as a bargaining chip. According to CBC News, when directly asked whether he was willing to use Canadian energy exports as leverage, Carney said he doesn't, quote, see the value in doing so, adding that when you're a supplier of a key commodity, you have to think really hard about not supplying it. When pressed a second time specifically about Alberta oil, Carney reiterated that being a reliable supplier is important, and that, quote, Canadians can be trusted, without explicitly ruling the option out entirely. That ambiguity, some value the option retains without ever pulling the trigger, is arguably the more accurate description of how Canada has approached this entire year of trade conflict with Washington. Not open economic warfare, not outright capitulation either. Something closer to constant, careful positioning, using legal victories when they come, using public messaging when it's useful, and reserving its heaviest tools without ever fully deploying them. It's also worth noting what Canada has been doing outside the negotiating room entirely. According to Yahoo News, as talks with Washington have dragged on through repeated stops and starts, Canada has been actively working to build trade relationships beyond the United States, which currently buys about 75% of everything Canada exports. The stated national goal, according to that same reporting, is to double the share of Canadian exports going to non-U.S. markets by the year 2035. That's not a minor policy footnote. It's a signal that Ottawa, regardless of how any individual Supreme Court case or tariff dispute resolves, is trying to reduce its long-term economic dependency on its southern neighbor, a dependency that this past year and a half has demonstrated can shift dramatically based on the decisions of a single president, or in this case, a narrow 6-3 vote on a 9-member court. Let's step back for a moment and put the legal mechanics in plain terms, because this is genuinely one of the more consequential separation of powers rulings in recent American history, independent of anything involving Canada specifically. The Council on Foreign Relations described the decision as a major victory for congressional authority, noting it reaffirms the constitutional principle laid out in Article 1 of the U.S. Constitution that the power to lay and collect taxes, duties, imposts, and excises belongs to Congress, not the executive branch. Roberts himself, in the majority opinion, wrote plainly that, quote, the framers did not vest any part of the taxing power in the executive branch, and that the government itself conceded the president enjoys no inherent authority to impose tariffs during peacetime. But the Council on Foreign Relations was also careful to note the ruling's limits. Its reach, they wrote, is narrow. It applies specifically to the interpretation of one phrase, regulate importation, within one law, EPA. It leaves the vast majority of existing tariffs on the books untouched. particularly the sector-specific ones under Section 232 that hit Canadian steel, aluminum, and lumber the hardest. And it opens up entirely new legal battles over whether tariff refunds will actually be paid out to the businesses that were overcharged, over whether the president's new Section 122 tariffs will survive their own legal challenges once that 150-day clock runs out, and over how a possible future Trump policy shift under the Loper-Bright precedent, a 2024 Supreme Court decision limiting how much deference courts give to presidential fact-finding, might reshape the next round of this fight entirely. None of that uncertainty was lost on Canadian officials. Even in the immediate glow of what looked, on the surface, like a clear legal win, LeBlanc's public statements consistently paired any celebration with a warning. The war, in other words, wasn't over. Only one battle had concluded, and Ottawa understood that better than most. There's also the looming question of the Canada-United States-Mexico agreement itself, the trade deal that underpins almost all of this. According to Yahoo News reporting from Ottawa, a formal review of CUSMA is coming up, a process built into the agreement that covers a combined market of more than 500 million people across all three countries. That review is always going to be a significant moment for Canadian trade policy, but the IEEPA ruling adds a new layer of complexity to it. If the White House loses more ground on tariff authority in the courts, some Canadian officials and trade lawyers believe the administration may push even harder during the CUSMA review to lock in permanent, congressionally authorized tariff protections that can't be challenged the same way EPA was. In other words, a legal defeat in one arena could translate into tougher demands in another, and Canadian negotiators heading into that review process are reportedly bracing for exactly that possibility. There's one more thread worth pulling before we close this out, and it's the domestic political fallout inside the United States itself, because it shapes how much staying power this ruling actually has. According to Rolling Stone's reporting, Republican reaction on Capitol Hill was notably mixed. Georgia Republican Congressman Buddy Carter publicly criticized the ruling. That kind of intra-party friction matters, because any long-term fix to give the president durable tariff authority, something that survives future court challenges, would likely require new legislation from Congress itself, and a divided Republican caucus makes that a much harder lift. It's also worth spending a moment on what this ruling means beyond just Canada, because the ripple effects touch nearly every country doing business with the United States. According to the Tax Foundation, the reciprocal tariffs alone had been applied to goods from nearly every nation on Earth, at rates ranging from 10% up to 50%, depending on the country and the product category. Mexico, like Canada, saw its non-USMCA compliant goods hit with elevated rates, 25% according to the Tax Foundation's breakdown, while China faced a flat 10% under the fentanyl-related emergency declaration, separate from the additional tariffs China faced under other trade actions. The scale of this ruling's reach is part of why legal scholars have called it one of the most consequential separation of powers decisions in modern American history, not just a trade footnote involving one country. For Canada, being grouped alongside dozens of other nations in a sweeping legal challenge meant that Ottawa's fate on this particular issue was never entirely in its own hands. It depended on a lawsuit brought largely by American plaintiffs, decided by American judges, under an American statute. Any leverage Canada exercised, whether through the Reagan advertisement, through diplomatic pressure, or through its own restraint on retaliatory tariffs, had to work within that reality. That reality also explains why Canadian officials have been careful never to publicly frame this as a Canadian legal victory. It wasn't one, technically. Ottawa was not a party to Learning Resources versus Trump. The ruling helped Canada as a side effect of a case fought primarily over the constitutional separation of powers within the United States government. That distinction matters for understanding what happened next in Ottawa. Rather than claiming victory outright, Canadian officials pivoted almost immediately to using the ruling as a talking point in ongoing negotiations, framing it as validation of arguments Canada had been making privately to American counterparts for more than a year, that these fentanyl-related tariffs were disconnected from the actual scale of fentanyl crossing the northern border. According to figures cited by multiple outlets covering the dispute, U.S. Customs and Border Protection data has repeatedly shown that the volume of fentanyl seized at the Canadian border is a small fraction of what's seized along the southern border with Mexico, a statistic Canadian officials have used repeatedly to argue the fentanyl emergency declaration, as applied to Canada specifically, never matched the facts on the ground. There's also the matter of how any refunds would actually get processed, and it's a bigger logistical headache than it might sound. According to Yahoo News reporting on the Canadian angle, one trade expert warned that in many cases the system for calculating and returning collected duties is still largely manual, meaning refunds could require issuing tens of thousands of individual checks, entry by entry, to importers across multiple industries who paid the disputed rates. That's not the kind of process that resolves itself in a matter of weeks. It could realistically stretch on for a year or more, layered on top of ongoing litigation in the lower courts over exactly which importers qualify. And for how much? For Canadian companies that paid the 35% non-CUSMA rate before it was later adjusted, that means the financial reckoning from this ruling is far from finished, even though the legal question at its core has technically been settled by the nation's highest court. For everyday consumers and businesses on both sides of the border, the honest answer is that very little changed overnight. Victor Schwartz, who runs a New York-based wine and spirits importer called VOS Selections, and who was one of the original plaintiffs in the case, told reporters the tariffs had been, in his words, arbitrary, unpredictable, and bad business, and said he was thankful courts at every level recognized the duties for what they were: unconstitutional government overreach. That's the voice of a small business owner who fought this case for the better part of 2 years. But even his victory came with an asterisk, because Trump's new Section 122 tariffs, signed the same day the ruling came down, meant many importers would keep paying a version of these costs regardless of who technically won in court. It's also worth noting how Congress itself has responded to being handed back a power it hadn't actively used in decades. According to the Council on Foreign Relations, the ruling reaffirmed that Congress, not the President, holds the constitutional authority over tariffs and taxation under Article 1. But holding that authority on paper and actually exercising it are two different things. There has been no significant push in either chamber to pass new, comprehensive legislation, setting clear rules for future presidential tariff actions, and with a divided Republican caucus, as we mentioned earlier, and a Democratic minority unlikely to hand the current administration a durable new tariff authority without major concessions, most trade analysts don't expect Congress to fill that gap anytime soon. That leaves the door open for exactly what's already happening: a president cycling through different statutory tools, Section 122 today, potentially something else tomorrow, each with its own legal vulnerabilities, while Congress largely watches from the sidelines. So where does that leave the relationship between Washington and Ottawa heading into the rest of 2026? The honest picture is one of managed, ongoing friction rather than resolution. The Supreme Court closed off one legal pathway the Trump administration had used, and it did so decisively, 6 votes to 3, with 2 of Trump's own appointees siding against him. But it left open several others, and the administration wasted no time walking through the next door the moment the first one closed. Canada, for its part, has spent the past year alternating between public pressure campaigns, quiet diplomatic concessions, and a deliberate refusal to escalate using its most powerful economic lever, energy. Whether that combination amounts to genuinely weaponizing a Supreme Court ruling, or simply reflects the ordinary high-stakes maneuvering of a smaller trading partner trying to survive a volatile relationship with its largest customer, is something reasonable people and reasonable governments clearly see differently. Before we close, here's a brief and honest accounting of where this story stands. The core legal facts, the 6-3 ruling on February 20th, 2026, the identities and votes of the justices, the immediate pivot to Section 122 tariffs, and the scale of tariffs previously collected under IEEPA are all confirmed through court documents and reporting from outlets including CNN, CNBC, NPR, SCOTUS Blog, and Reuters. The Ontario Reagan advertisement, Trump's termination of trade talks, and the Reagan Foundation's objection are similarly well documented across multiple independent sources, including PBS and the Associated Press. What remains genuinely contested, and what we flagged throughout, is the underlying motive behind that advertisement, whether it was designed to influence sitting Supreme Court justices, as Trump claimed, or simply to shape American public opinion during a trade dispute, since no Canadian official has confirmed the former on the record. Similarly, the direct causal link between the streaming tax decision and the broader trade negotiations remains something analysts are still piecing together rather than a confirmed fact. What do you think? Was this a case of Canada strategically using every legal and political tool available to protect its economy, or did it cross a line by trying to influence an ongoing U.S. Supreme Court case? And with Section 122 tariffs already ticking down toward their 150-day expiration, do you think Washington and Ottawa are actually any closer to a lasting trade deal, or just buying time until the next legal fight begins? Let us know where you land on this one. Thanks for watching, and we'll see you in the next one.